Good morning, everybody. On behalf of the Indo-American Chamber of Commerce, Karnataka, Raj, I extend a very warm welcome to each one of you for having joined us here today. More so to person, it's nice to see all of you after 2 years. I would like to now invite Vice Chairman, Senior Vice Chairman, Mr. Chandrakant BN, to deliver his opening remarks.
Welcome again on behalf of the Indo-American Chamber of Commerce, Karnataka. We are living in some very uncertain times, and just as we thought that we got rid of this COVID nonsense, Russia decides to invade Ukraine, and here we are, thinking about the new world order, what's it going to do to us. But anyway, we have limited control over some of those things. So back in the room today, we're going to talk about data protection and how it impacts India. India generally, if you look at it from a digital adoption perspective, we've come a long way. Just a few years ago, I come from digital marketing, online media industry. And just a few years ago, I remember talking to marketers, nobody was willing to spend more than 2-3% of their overall budget on digital. But today, digital marketing is mainstream. Everybody is using it. Similarly, if you think about e-commerce industries in India, when they started out, they were all struggling. They were unable to be profitable, primarily because a lot of people in India were scared to use credit cards. Credit card was not something that people were willing to use because they didn't know what would happen when you give out that data. But today, even your roadside sabziwala will take digital payments. So there's a long transition or an emergence of a digital economy that has happened very quickly in India. And I think pandemic has also sort of pushed it faster, and that adoption is very quicker in some sense. I was at a restaurant last night, and after dinner, I said, can I get the check? He said, sir, here's the digital notepad, and you need to sign on this, and I'll send it to you in an email. I said, I'm not giving you my email. Why will I give you my email? But, most places we go today, they ask for phone numbers, emails, and our personal data itself is being asked everywhere, and we are giving it away. Some cases we may say we won't give, but some cases we are giving without knowing. I mean, there's our digital footprint is everywhere, whether we like it or not. And what does this mean? So much of digital, what does it mean? It also means a lot of data. So that data that those digital industry, digital world is creating is humongous. So the owner of this data has suddenly become very powerful. So as a consumer and as somebody who is giving away this data, where is our privacy? Is privacy a myth today? So on one side, we have businesses which need data to function, and on the other side, we have consumers who are worried about their privacy in the future. So it creates a very interesting conundrum. So the data protection bill, I think, is looking to address some of it, while on one hand, you want to bring in law to protect consumers, protect businesses. It can also act as a sort of something which is going to make, make business difficult. So we need to look at both sides. And from ISCC, we've seen some other people come and present, lawyers, media, etc. But today we have a perspective of compliance. So we are really looking forward to today's session and hearing Mr. Navi and his team and people from the Foundation of Data Protection Professionals in India share with us their thoughts on this subject. We are very thankful to them for being our knowledge partner, and we are really looking forward to today's session. And we'll wish you all a warm welcome. And again, thanks for coming today in person, and also those of you who joined digitally, welcome. And look forward to the session, Mr. Navi. Thank you very much.
Thank you, Chandrakant. Yeah.
I'd now like to invite Mr. Navi, who's the chairman of NDPPI. He's a pioneer in cyber law and data protection in India, an ex-banker with wide experience in marketing, banking, and information security. He's a man with a mission to spread knowledge of cyber law and data protection that it reaches to all. He presently leads the activities of NDPPI as a founder and chairman. Welcome, Mr. Navi.
Thank you, Jitika, Chandrakant, and other members of ISCC, and also the people who are here, both from ISCC as well as FDPPI. We are having a physical conference after a very, very long time, so it's always happy to see each one of you face to face. I also welcome the people who are there on the Zoom as well as on YouTube, who will be silently listening to the deliberations here. So as Mr. Chandrakant was telling, we have been having lots of discussions on data protection, new version of the data protection bill. You know that the PDPB 2019 has been there in the parliament since 2 years, December 2019. And subsequently, the Joint Parliamentary Committee had 80 plus meetings with all the stakeholders. In fact, companies like the Amazons, the Facebook, they were all invited to the JPC committee. A few of them did not attend for their own reasons, and now they are looking back and say that I have a different view. An opportunity was given to all of them. Imagine even they gave the opportunity to us, FDPPI, to come there and present for more than an hour when Meenakshi Lekhi was heading the panel. Subsequently, you know that Mr. Chowdhury took over, and the JPC2 made some more changes from whatever was there earlier. And we have now a version which we are identifying as Data Protection Bill 2021. When the act is passed, it will be called Data Protection Act, and we are already in 2022. Therefore, it will be called DPA 2022. It cannot be called DPA 2021. But when we use the terminology DPA 2021 or DPB 2021, please remember we are referring to this document, which is the JPC approved version of the amended Personal Data Protection Bill of 2019. And since it has already been tabled in the parliament earlier, any day it can be picked up for a discussion. Our Honorable the IT Minister has told that it is the intention of the government to get this passed. If possible, in the current session, one more leg of the session is starting on March 14th, or at least in the next monsoon session. So there is a lot of activity. And now suddenly, as it always happens, when we are very much near to the law making, then industry wakes up and says something is not acceptable to them. And so they are all talking of what further amendments have to be made after 2.5 years of deliberation. Most of you may be aware that India first actually came up with a data protection bill in 2006, along with the amendment to Information Technology Act. That Information Technology Act got amended in 2008 and it became a law. But this PDPB 2006 was never passed into a law. So we are now in a situation where the new law is ready for the further discussion. And what we have seen in the media in the last few days have been various objections to the bill, okay? And some of them are going to the extent of asking that we should shelve the current version of the bill and start a new drafting, which means that another 3 years or something like that. It is another way of saying that we don't want data protection law in India. In fact, it is this same industry which was even in 2006 was clamoring for a data protection law in India because they felt without that law, we will not be getting the data processing business, particularly from the EU region, which has always been in the forefront of privacy protection. India had this Information Technology Act in the year 2000, and in 2008, they made substantial amendments to the Information Technology Act so that it became a more robust data protection law. In fact, Section 43 capital A of Information Technology Act, along with the reasonable security practices guideline, which came in April 2011 after a gap of a few years, actually it is a complete code about data protection. In fact, if you check the chapters of Data Protection Act, you will find each chapter represented in one rule of this reasonable security practice in a way. So most of the activity, things which are there in this Data Protection Act are represented in this reasonable security practice, though you can say it is an abstract or a one line for one chapter or something like that. This new Data Protection Act has been recognized more for the new authority which will come in India. Data Protection Authority will come. People say there was no Data Protection Authority earlier, but I have been telling that there was an official called adjudicator under Information Technology Act who had even suo motu powers to take up inquiries. And if there was any data breach or even a suspected data breach, the IT secretaries of every state who were called the adjudicators under Information Technology Act had every legal right to actually act like a data protection authority. It is true that nobody wanted that responsibility and nobody did it, but I'm mentioning that to say that the amended Information Technology Act, which is a 2008 version, had most of the provisions which we today aspire in a data protection act. But still, today we are asking for the government to take a relook at this. And that is where I felt that we have had enough of discussions. Now, if the government comes up and suddenly in 2 days, you know, sometimes if the government wants to pass the bill, it will get passed in 2 days. There will be very little discussions. If it happens, then we will suddenly have a big law in front of us. I don't want the industry to be surprised with the law, and therefore we are saying that we should get ready for whatever draft version is there. And if this draft version is further changed, doesn't matter. We know the changes can be only cosmetic. Their data protection principles in general are same worldwide. Okay, there are certain rights, there are certain principles, and there are certain cross-border restrictions and compliance and accountability requirements. Okay, so there will be changes here and there, but basically those principles will not be changing even if a new version will come. So therefore, it is a good time for the industry to actually start working towards compliance. You see, compliance of data protection law is not an overnight activity. No organization will be able to do it overnight. It will take months, okay, not less than 6 months. Even if you are with a good consultant, it will take that much of time. Even then, we do not know whether the privacy culture will be there in every nook and corner of the company. That will take years, perhaps. So, knowing that there is a time required for implementation, organizations need to start working on the compliance. That is why we need to look at DPA 2021 from the point of view of industries who think positively that if this law comes from tomorrow, then how do I comply? So that is the compliance view of this DPA 2021, which we would like to discuss. It is unfortunate that nobody else is discussing the compliance view. Everybody is expecting that the law will be changed. Okay, so why we should take it? In fact, people like us have worked on Information Technology Act, and we know that from 2000, people never realized there was a law. It was only in 2011 reasonable security practices came, companies really realized, oh, there was an act. In fact, all our initial discussions with companies initially was people will first ask, is there a law in India? Okay, and then we have to say it already came from 17th October 2000. Okay, so hopefully this DPA, that is Data Protection Act, will not take 20 years for people to realize its presence. So I would like to see that industries gear up towards that. Bangalore is the best place to start with this kind of activity. So that is the context in which we are discussing today. So when we are looking at Data Protection Act, you must understand that it is a balancing act for the government also, because we have the kind of stakeholders like the individual who wants privacy. When we say privacy, we want to ensure that nobody knows who am I. Okay, I'm talking here now. We have got this virtual conference. People are logging in. We are perhaps recording this. So there is a privacy issue. But there are some people who will log in assumed name. They don't want to say who they are, kind of a thing. So individuals sometimes thinks privacy as a means of hiding his identity, and he will not be satisfied until the last element of hiding of his identity. That is one extreme. Privacy activists are going to support that view. Now, businesses, on the other hand, they look at data, particularly personal data, as a monetizable commodity. They want to make money. If data privacy is taking over 100%, then all the IT companies, many of the IT companies will have to close down because they will not have any business model, because data is a valuable commodity and they have to, when they have to monetize, they need certain personal data. So that is an opposite viewpoint compared to the privacy activists. The government has to balance these two views, and also they have to remember that they have their own responsibilities of security, and they cannot say stop all the CCTVs on the streets, because today whenever a crime happens, the first thing the police see is the CCTV footage, and then they will go to the tower data of the mobile. That is how at least some crimes are getting solved. They may not be cyber crimes, even normal crimes are being solved only with the assistance of CCTVs and mobile data, which definitely from the privacy point of view can be questioned as surveillance. We cannot say that let the crime happen, then we will switch on the CCTV, because surveillance has to start when nothing is happening, and then things will happen. That is how most of the CCTVs today are configured also, that when there is a movement, then it will wake up, is it not? So it will otherwise lie silent. So government has to ensure that its duty to secure the society is not hindered by the excessive privacy obligation. So this is the balancing act, which makes formulation of an act like this very, very difficult. Now, so we are seeing in the market discussions, privacy activists saying Section 35 of DPA is draconian. It will give so much of powers to the government that we will have a Orwellian state, government looking at us in a very way. Businesses, on the other hand, are saying, oh, you are bringing in consent. Now I'm happy without consent, I'm collecting all the data. Now you want consent, you want me to give a notice. And if somebody wants to withdraw the consent, then what should I do with that data? You are hindering my business opportunities. Plus, you are asking me to be accountable. That is the compliance. This thing, if you say GDPR compliance, then same way you will be having DPA 2000 compliance. So you're asking me to be accountable to what we are doing. Indian law has gone to one additional stage saying that I will give you marks, data trust score, and I want you to show that DTS score on your website, on your notice to the data principal. Let people know that XYZ company is asking for my personal information. Its data trust score is only 30. Another company data trust score is 60. It is giving the same service, but its data trust score is high. So I would rather take the service from the company with a higher data trust score than a company with the lower data trust score. So compliance is not going to be just a documentation. Ask somebody, pay some 2 lakhs or 3 lakhs and ask a certificate. I am compliant with GDPR. Today, ISO certificates are available in Bangalore for 15,000 rupees, 10,000 rupees or something like that. Okay, 27001. People are offering that to my company, which is a one-man company sitting in a small this thing. But what is required is compliance in the real sense. Okay, that is the issue which companies have to face. If somebody says there is a cost to that, yes, there is a cost to that. You cannot have compliance without cost. There are certain technical issues. I have to change my technical architecture. I have been telling companies, if you don't want to change your data processing technical architecture, have the use of a pseudonymization gateway approach. Okay, when data flows into the company, pseudonymize it, then retain all your current processes. And when the data exits, you re-identify, then the compliance cost for the entire GDPR or DPA compliance boils down to setting a incoming filter and an outgoing filter. So that is the ease with which you can implement most of the provisions. But companies have to put their head into action and find out. They're all very innovative in so many other ways of introducing new services. But when it comes to internal improvement, many times companies are not being innovative. Okay, so that is the business issues. There are always eternal naysayers. Whatever you do, we will find a problem there. I am actually better than many others if I want to do that. Okay, but unfortunately, this kind of a law, which has to balance these multiple stakeholders, will be one which will have to be passed, even when somebody will say that I have given up something. Somebody else will say I have given up something else. So it is a mutual give and take, and that is how we have to go ahead. Now, if we look at the major objections, say one is activists are saying disproportionate exemptions have been given to the government under Section 35. Social media intermediaries are in the forefront of objections today because the government says that you have to allow a customer to identify himself. See, Twitter already has got something called verified accounts. That is what this law is telling, make that mandatory. Mandatory in the sense at the option of the user. That is, user, if he says, I want to identify myself, any message which comes on Twitter should come with my verified ID. That is what social media intermediaries are supposed to do. And I don't know where is the question of objecting to this. It is not a technological, say, rocket science to provide that. Whether it is Facebook, whether it is WhatsApp, everybody can have that verified ID. Then part of the cyber crimes which are today happening through impersonation on the Facebook and other media will reduce if this verification is made available. But social media intermediaries, they don't want to do that because they actually thrive on this fake news being in circulation. In fact, when cyber laws, when we were objecting to obscenity, we know that a lot of people, including ISPs, said we don't want to block obscenity on the internet because 80% of our traffic comes from obscene websites. So why do you want to block it? So same way, here also social media intermediaries do not want to stop fake news this thing because that if it is not very damaging, it is gossiping, all of us will be happy. But today it has gone beyond gossiping. And the social media intermediaries actually want to create opinion. Sometimes they want to work for regime change. They have become political. In fact, unfortunately, this thing has taken this politicization of business to a new level in the form of sanctions. Sometimes we are actually joining the war front. In fact, you know, in cyber war, we say active war and then information war. If the government itself is doing an information war, then it is a hybrid war. Let them fight. Cyber warriors are there, cyber soldiers are there, let them fight. Like the persons with the gun, they will also do it. But today, like it is happening in Ukraine, we are asking the civilians actually to take up the gun and fight. Same way now, private sector companies are also, with a misconception, they are getting into the war front. Now, I feel multinationals have a very big responsibility, just as India has remained non-aligned. It is not because we can't criticize Russia or something like that. We are non-aligned because we know we have to balance. MNCs and companies also need to actually be non-aligned in certain circumstances. This is the kind of situation you are having. Now, industries are talking of this cost of compliance, etc., which are being reflected by the industry associations. Things which are now being objected to are cost of compliance, restrictions on cross-border transfer, fear of penalties. Okay. So in this context, what I would like to say is, let us put all these objections to the side and look at what are the positive features. Just to tell you, this particular act is nothing much different from other things. It is like our GDPR or CCPA kind of a thing. It is applicable for all personal law collected, processed, shared or disclosed in India, because that is the territory in which the organizations live. It is also applicable to Indian entities if they are doing business outside India, for which certain exemptions are provided. Okay, suppose your company is a multinational and you are having a business in Germany, you can get that business exempted from here so that you don't have to fight with the GDPR compliance and DPA compliance simultaneously. That is different. This is different. Government is willing to give exemption for this. And innovation is supported by giving this sandbox arrangement. Then there are a number of exemptions which are given for the ease of doing business. People are today threatening the government, saying that if you implement this, ease of doing business will get affected. But actually, there are so many exemptions which actually provides for ease of doing business compared to what we call as a golden standard, GDPR or something like that. Now, what this act expects is, here is 99 sections of this act. Please process the data in accordance with this act. That is what we call as lawful basis. In fact, DPA 2021 has simplified the definition of the lawful basis. And if you work within this 99 sections, you are very much in compliance. Many people say consent is mandatory, but consent is mandatory, but there are exemptions. It means that consent is not mandatory only. So it's a question of how we put it across. Say GDPR says consent is not mandatory, but you can do this. Here we say consent is mandatory, but you can have exemptions. You can exemptions for information security. You can exemption for whistleblowing. You can have exemptions for credit rating, exemptions for debt recovery. So there is and for employees, certain exemptions are there. You have got exemptions for public data processing in India. So therefore, there are a number of exemptions for consent, and therefore to say consent is mandatory is half truth. You have to look at it with the various exemptions. And as far as the rights are concerned, we also have the rights to guarantee access, portability, correction or the quality, and right to forget. In right to forget, we are a little bit careful. We say it will be allowed only with the involvement of a quasi-judicial authority. That is, the adjudicator has to approve for right to forget. It will not be voluntarily done. So therefore, we can say DPA 2021 is similar to other laws, but there could be various exemptions. As far as penalties are concerned, also we are matching the GDPR, 2%, 4% of the total worldwide turnover. 5 crores, 15 crores is there, but whichever is higher is applicable, so it doesn't matter. So that is the what GDPR has taught us. But GDPR has today imposed fines nearing 1 billion. Okay, Amazon and Google are aware. I don't think 1 billion US dollars. Okay, this Amazon faced 887 million US dollars. And it was done by a country called Luxembourg, supervisory authority. And if you distribute this 887 billion orders, there's a per capita charge of 2 lakhs per citizen of Luxembourg. It is like a city, and they want the Amazon to pay 887. This thing, they can actually put it in their budget. Okay, so I don't think Indian data protection authorities will have something like 5,000 crores fine and other things. In IPC, we are still in thousands actually, to lakhs. And in TRA and other things, we have slowly come to crores, a couple of crores. So I don't think we'll go to hundreds of crores. It's a long time, this thing. So people need not be afraid of penalties is what I am trying to say. Now, there are certain compliance obligations which may be of interest to you. One is that we call it as privacy by design policy, then DPO at a KMP level. So it is people who are aware of company law should know that key managerial personnel is at the top level of management, and you want the DPO to be at that level. And I think all the present DPOs should be happy that they are going to be promoted and elevated very shortly. Now, technically, the challenges are, of course, there is something called transparency in algorithmic processing. That is, you cannot say, I've got a black box, I will take the personal data here and do something. Don't ask me what I am doing. I also don't know. Okay, only my R&D person knows what happens inside this black box. So what this law may say is, at least give me an assurance, give me a certificate that you are not violating the consent clause or rights clause or etc. when you are saying that I am processing it with a certain secrecy. It is not expected that you will have to give the codes to the Data Protection Authority or something like that, because Data Protection Authority will come up with detailed guidelines. I am sure that they will not say, I want a copy of your IPR protected codes or something like that. But they will expect an assurance. In fact, there will be third-party audits which are equivalent to this bias audit, which may happen elsewhere. In USA and other things, bias audit is done only for racial bias of this automated processing. Here, we will be doing a privacy compliance audit. Okay, and that will be done by a third party, and that third party assurance will be what perhaps the DPA will be asking. So no IPR loss could be there. Cross-border transfer, actually, in the latest version, there are no restrictions at all. Say non-sensitive personal data can be transferred freely, there's no mention. And then sensitive personal data and critical personal data can also be transferred, provided you have an explicit consent for that, and you have to keep a copy in India. That's all is being asked. Okay, in the PDPB 2018 version, we wanted the entire copy to be there. In fact, today I want that back, because if a situation like the sanctions come, if Google stops Google Map and Visa stops processing, then where will India go? So at least if you have a copy here, we can do something. So I think it is not only a law enforcement requirement to have a copy in India, it has become an issue of national security. Now I will have my panel members discuss this in great detail. I'm just trying to put these issues in front. But remember one thing, because Information Technology Act is already there, there is Section 43A, there is reasonable security practices, within which there is a concept called a due diligence. Now this act has been put into the bill. The committee itself says we will give a minimum of 2 years for implementation. Now, throughout this process, the bill becomes a due diligence under Information Technology Act, because due diligence is a concept which says that whatever is good, best practice should be followed. That best practice may come in various phases. GDPR itself is a best practice. HIPAA itself is a best practice for India. Similarly, DPA 2021 is the best practice to the industries. In fact, there have been court decisions in the last 1 year, 2 years, in which they have quoted PDPB 2019 sections and then given judgments, which means that even this bill PDPB 2019 was taken for judicial recognition. So DPA 2021 will also be done like that. Therefore, it is part of the current law as a part of due diligence. So there is no 2 years, you have to start being compliant today itself. you can always fight for lesser penalty if something goes wrong. Now, the real concerns which you have to be worried is, there is something called registration. Some of the significant data fiduciaries need to get registered. Now, what is this PBD policy? How is it, this privacy by design policy? How is it different from the privacy by design in GDPR? How to identify a good DPO, given all the complex states? This is what top management has to start working. Today, there should be a board meeting to say, how do we select a DPO for our company? Okay, rest of the things will come later. Now, the government has given 3 months for setting up the data protection authority. Now, in a company, we may sometimes require more than 3 months to have a senior appointment at the KMP level who has got this. So the companies should start identifying DPOs. Some companies are already losing good people. Ramesh was available until a few months back. Now he's no longer available. So good people will be taken away by other companies. So companies need to act very fast. There is something called security certification for hardware and software, which is something which you need to look at. This as cyber security people have been asking for this certification of security certification. Indian Institute of Science long time back had started one a committee for this. Now government says we will set up certification labs across the country, which will be capable of giving security certification for software and hardware, which means all applications on mobile will be certified by these things. The certification is, there is no malware in this. That's all which is being asked. The rest of it, privacy is taken care of by the privacy compliance. Lot of business opportunities for both the auditors as well as companies who can develop tools for this. So fairness of algorithm, these are all issues which are really concerns, but you need to do something for that. How to develop notice, what is DPIA, data protection impact assessment. These are all things which you are aware. Indian law has something called consent manager. You must, perhaps we will discuss it in detail later, but remember that is also an opportunity. I am talking of industries to actually look at it. Then verification of age in case of minors, then something called nomination. These are all the issues which you have to see. Now, public available data. Remember that GDPR concept could be different from Indian concept. See, today, in the absence of any precedences, we simply go to the GDPR tracker and see what are all the fines which are being given for various purposes and try to take that as a guideline. But Indian law could be different. So the public data usage as per GDPR may be much more stringent than in India. So we will have to develop what I call as jurisprudence, that is data protection jurisprudence. It will happen. DTS score is going to be some of more interesting thing. Now, one of the issues people are saying is that you have combined personal data, non-personal data into one law. It becomes huge in scope. But remember, what government has done is, one, they have tried to protect themselves. Why they wanted to protect themselves? They had one section earlier, this thing, it was section 91, now it is section 92. It said that government has the power to direct any data fiduciary to get some data in anonymized form, not personal data. If there is anonymized information available, some surveys or something like that, which will be useful for governance, they had a provision that we have an empowerment. So people started asking, this is a Personal Data Protection Act. How can you make a mention of non-personal data in section 91? It's ultra wires, this kind of a thing. To avoid that, the government said, okay, I will make this act itself as non-personal data. That was the major requirement. Then in the notification, they felt that companies sometimes do not know at the time of notification whether personal data has been breached or non-personal data has been breached or both have been breached. So they said data protection breach notification, whether it is personal or non-personal, don't sit in judgment of that, report it to me. But if you see section 25 of this act, whatever guidance they are trying to give, they are only for personal data. Non-personal data, they are still saying that we will perhaps say something because certain is already there. So only in one place, this is section 25, there is a mention that non-personal data breach has to be mentioned. So don't get confused with the discussion that this is a personal and non-personal data protection act, because non-personal data protection act has been there in India since 17th October 2000 in the form of Information Technology Act. We don't need any new act. So this is the real concern. In fact, because we are one of the 100 and odd countries in the world which is going to have this kind of a law, we always have a problem that a company, when it opens a website, people from all the 100 countries are going to come and then give me data. So I'm to be compliant with the GDPR, CCPA, Brazil, etc., etc. This is going to be something which we need to look at as a real concern. Of course, FDPPI is trying to do something with a framework, which is the Data Protection Standard of India. Earlier, we used to call it as PDPSI, Personal Data Protection Standard of India. We have ran with the government. Government says personal data, non-personal data is one act. So we have also said PDPSI cannot remain as PDPSI. We will make it as DPSI. So Data Protection Standard of India, we have done in such a manner that a unified framework for compliance of not only the personal data protection, but also non-personal data protection and also GDPR is what is being suggested there. There are some very interesting concepts there. We don't have time to discuss that. HR concepts like distributed responsibility, data valuation. Those of you who have time, you can read it separately. If possible, we'll give some more references to that. So this is in general what we are talking of as this new Data Protection Act 2021. Now that we have our expert friends here in the panel, it is time to actually throw the questions to them and then get their thoughts into it. I thought it is necessary to give an introduction so that you can raise questions to them. Otherwise, if you are not aware of what is there in DPA 2021, it will become a monologue from the three experts. So I wanted you to have some basic understanding, and that was the purpose of this introduction. Yeah, now I think we can open the next section of the panel discussion. It should start with Aishanya coming here for introduction of the panel. In the meantime, if you have got any questions, you are welcome. Before we open the panel discussion, if you have got any questions to me, please let me know. Yeah, please. Yeah. Say sectoral regulations will be there because health data, finance data, they will still be their genetic data. These are all considered as sensitive personal data. Now, the moment you have non-personal data, the sensitivity is not in this kind of categorization where you do harm analysis. That is, what is the harm which is likely to be committed to a data principal if his health data is breached or finance data is breached. Non-personal data, you discuss it in a different way, like whether my company's IPR is being lost, whether a cyber crime attack is going to happen on my corporate assets. So those are the things which you are today trying to address in terms of classification of data in general, like say confidential or public or private, employees only. That kind of approach will continue to be there for the personal, for the non-personal data. Responsibility for protecting the non-personal data, that doesn't have any relation to the privacy protection. You know, this particular act is for protecting the right to privacy. I am not worried about the right to protect the data of a company in this act. That for that I have already made this 2000 Act of ITA 2000. I am giving up to life imprisonment for people. Okay, 3 years, 7 years, 5 years imprisonment for various kinds of offenses. That is the protection which the government has already given. You bring this nonsense and non-personal data risks under ITA 2000. Okay, this personal data, bring it under here. There the sensitivity, harm, and other things will have to be looked at. Okay. Yeah. Yeah. Yes.
We move forward to the panel discussion now. Introducing the panelists. Mr. Manish Kanwal is an ISCC member and is a part of the South India Council at the moment and is the convener of the SIC Cyber Security Forum at ISCC. Manish has more than 20 years of experience in IT services industry in US and India. His areas of expertise include IT governance, risk and compliance, data privacy and IT management systems. He currently leads the portfolio at L&T Smart World and Communications. Prior to this, he was a co-founder of a cybersecurity startup consulting firm focused on serving clients in US and India. He is a certified data privacy lead assessor from Data Security Council of India. Our second panelist for the day is Mr. Kuranjaram MG. He is an IRS executive who retired as an assistant director of customs and central excise. He has worked in all important formations of customs, be it excise, service tax, CESTAT, and anti-smuggling units. He also served in Sahara International Airport in Mumbai as an intelligence officer. Welcome, Mr. Kuranjaram. Our final panelist for the day, Mr. Ramesh Venkataraman. He is the manager at Scalzi's, handling QMS and ISMS. He has over 30 years of professional experience in the software and systems engineering field. His core competencies include software process improvements, training and coaching, audits and assessments, and staff mentoring and management. He has extensive experience establishing process improvement programs for various organizations based on standards, models, frameworks, etc. He's worked with several organizations, including Cognizant, Symphony Teleca, etc., in various capacities as a senior manager in training and development, audit and quality assurance. Welcome, Mr. Ramesh.
Yeah, now we will throw some interesting questions to some of these panelists so that we can start our say discussions. So I think we will start with the basics, that is this inclusion of personal data and non-personal data into one act, having one regulatory authority. What would be the implications of this? I would like to start with Mr. Kodandaram and ask for his views on these implications, because he's also a person who has studied ITA 2000 in a big way, which was already handling both personal and non-personal data. In ITA 2000, we were not distinguishing it. So to protect it under section 43 or 43A, and then if you're not doing proper job, then wrongful loss will be adjudicated, and either you may pay compensation or you may go to jail. That was the concept of ITA 2000. Cause of action had to be there under that. So now we are saying that we are having one more law. So let us have his views on this combination.
Yeah. Thank you, Navi. Thank you, Hankalji, and very happy to be here. After a long time, I'm able to come out of my home, duly permitted by my wife, because it's only online sessions which I was handling. Now I feel more refreshed to sit amidst you. Before going into this personal and non-personal, I would like to look into the lawmaking aspect of India itself. We have been a very, very poor people as far as lawmaking is concerned. That's my most worried aspect. When I teach Evidence Act, which is more than 150 years old, I have to bring in the electronic document and the electronic forensics sciences which I have learned now into that, saying that there's a neutrality in the law and I need to adopt what was written 150 years ago to be amicable and answer today's evidence, which certainly I will fail. I know it. It's impossible. You take it other criminal legislations like Criminal Procedure Code or Indian Penal Code. We say, oh, that is even today very good. I do not admit it. I tell you, there are all certain lacunas which are 150 years old, and they were the laws made for the physical world, not for this virtual world. We have come out from the common good of a physical world to a virtual world where it's kind of another dream. It's an innovative, another media. The earlier laws are no more valid. They have to be rejigged, redesigned, and made into. And the way the technology is developing. Today we are talking about data, digital time. That will be over. By the time we make the law, that will take up by metaverse. Mr. Naviji, I have been following him from last 30, 35 years or so. So I am traveling with this journey, I know. By the time I come with the personal data, it will be invalid data because metaverse would have taken up for a new dimension. So there the challenge is. The legislations, the legislators of India should understand and realize when 130 countries of the world over have brought in this privacy law, we are still lingering and tinkering with this. Is it proper? Number one. Second, coming to that, unless we are able to move with the technological developments, the legislature also should move hand in hand, in line with that. Then only Indian people can be safe. Otherwise, there will be an onslaught of technology on the human race, which is really very, very tough to bear with. Today, that's what is happening in my society. That's what is happening in my family. That's what is happening in the roads. That's what is happening in agitations world over. Unconcerned, uncornered. Now, coming back, we were talking about let's have one authority for both commercial data as well as non-commercial data or personal data. Hitherto, we are having the same thing. Information Technology Act provides for it. Section 43A says that there is a secretary who will adjudicate. There is a person who will take suo motu. All that is written. Have you heard of anybody seeking any relief under them? It is not that they are not willing. They want to go and appeal, agree, but they know that there will be no answer. I tell you, the bureaucrats are the second line of people who have never cared for the privacy of the people. They are not worried about the citizens' rights. What is assured in the parliament or what is assured in the constitution is the individual's right. It is not the business. That's more important for life. For me, living with dignity, living with morality, living with ethical practices in life, they are all of permanent value. All others will come and go. We are talking about the days of our traditional old one where we have not invented a printing machine. We passed through the printing machine. Industrialization is over. Now it's an explosion that has happened about the information technology. Metaverse is going to make us kind of a mad guys on this world. What is this unless you take up the law? Secondly, if you mix with commercial people will certainly take over. Business interests will take over. The individual's fundamental rights will suffer as on today. It is suffering. There is no adjudication, sir. Kindly take it from me. You may quote that there is so adjudication. It's only in the law. On the action side, not even 0.1%. If that is the way, DPA is going to be treated. Certainly no private fellow will get any relief. So it's a very, very bad area to bring in commercial aspects to this. This is a unique law where citizens' rights have to be protected. Like RTI Act, it's a practical regime for Article 19. This is a practical regime for Article 21. The right to life. Pehle mere jine do. Uske liye kanun ko, why you are mixing it with us? Why do you bring the business people? Only when the society exists, business can flourish. That business people also should think of. It is not the business that's the core issue in a society. It is the ethical and moral living with a value that should be at the center. With that, if you have kind of development, then that is a real development, value development, which will last long. So therefore, it is a very, very poor idea to bring in personal data and non-personal data together under an agency. And I will assure you today itself, in your forum, nobody will care for privacy complaints. Take it from me, sir. That's my call.
Okay, now let me get Mr. Ramesh view on this. As I have told, actually the provision of non-personal data in this is very minimal and left to the discretion of the Data Protection Authority tomorrow for doing more. But as I also told, I told about the compulsion the government had because people for privacy activists went indicated going to the Supreme Court saying that you are talking of non-personal data in Personal Data Act. Therefore, we will challenge it for having violated the the directions of the Supreme Court. This is my reading of that. Unfortunately, government fell into the trap. I have called this as a trap. Okay, government fell into the trap and said that, okay, we will make this this. So let me hear the views of Mr. Ramesh also.
Thanks, Mr. Navi. A very good morning, all of you. And to be having a different kind of problem. Today, I'm going to be sitting on a kind of good cushion that, when a breach happens, I will look at both and trying to look at what kind of impact. And reporting is also made easier in terms of, directly reporting only to the DPAI in both the cases. So it's going to be quite interesting. And even in the new law, as he again mentioned correctly, in the opening remark, there are only 2 references to non-personal data in the new avatar, DP PB 2021 we are talking about. Section 25, addressing reporting of data breach, as I already touched upon, along with the personal data breach. Please report to non-personal data breach also to the DPAI. And second, section 92 talks about active promote framing of policies for digital economy, including non-personal data. That's all we are talking about. So the kind of measures what organization is going to put in adhering to, in implementing to the data protection, personal data, if I have to say so, same thing holds good for non-personal data also. So let's take the advantage is what I would say, thinking from the positive perspective of inclusion of non-personal data. Yes, sir.
Okay, thank you. Panish, if you want to add.
Yeah. For me to add, from an industry perspective, I would say that this inclusion of non-personal data, this would open up business opportunities for software algorithmic certification labs across India. So I think,
Okay,
that's an input from us.
Thank you.
Yeah.
we have also started getting some questions on the online, so that we will also take up that in between. Okay, so one of the attendees asking, of course, when the act is going to be enacted, and is there any definitive answer for that? The only answer we can say is that the Minister of IT made a mention recently that he expects it to be passed in this current session, failing which in the next monsoon session, we'll keep it as that only. Now, I would like to ask Mr. Panish about this data localization requirement. What is present in this Data Protection Act 2021 version? How does he, as a representative of the industry, feel will create hurdles? Yeah, Panish?
Hurdles. Okay. So with respect to the data localization requirement, there is a requirement that sensitive personal data may be transferred outside India, and we shall have a copy of that sensitive personal data for processing in India. That is one thing. And critical personal data shall be processed only in India, as it may be deemed by the central government. And here the law enforcement agency databases and other things come into the picture. So here, some of the hurdles is with respect to the section 35. Yeah, yeah, as part of this two sections, those 2 points in the sections, that is the overarching powers of the government in this regard, I think those could be some of the areas in which more discussion and deliberations have to be done, sir. Yes.
Mr. Ramesh, can I add anything, sir?
Yeah, sure. Again, it's very good that, as again, he, in his opening remarks, he already touched upon that, quite interesting. Not like GDPR that we are talking about something, very stringent, flexibility is provided. If it is an ordinary personal data, absolutely it can be transferred, no issues. If it is a sensitive personal data, that law clearly says, please do transfer, keep a copy of the same over here. If it is a critical personal data, of course, it's yet to be defined by the law. Once when the DPA comes into picture, we may be hearing about what comes under critical personal data. But the only restriction at this point regarding the critical personal data transfer, it needs to be maintained here. Of course, there is a kind of rider over there. This can also be transferred if we have an explicit consent. So I don't see any kind of problem, but it's better to have a copy at our side, as he talked about, tomorrow kind of situation, what we are facing in the world today, sanctioning or etc. So it's always better. And I don't see any from the negative perspective on this particular article. Yes.
So I would like.
Sure.
Yeah. See, it is always a practice to have copies from the point of view of security also, backup copies. Okay. So backup copies can be in different countries. India can be a center. It is going to give a lot of opportunity for opening up of new data centers, expansion of existing data centers, accompanied by the staff and employees required for that purpose. Yeah, but
Here only I would like to add, sir. The interest pertaining to the privacy of an individual has been now transferred how industry can be related or how industry can use. That should not be the aim. The personal data should be towards the privacy of the people. For that, I do not agree only the sensitive and critical data are kept. Every data which is a personal data shall be preserved in India. It's my data, it's my country's data. Tomorrow, if you say, sir, I have transferred, I thought it is not a sensitive data, sir, it is not a critical data. We are giving a opening to them. And secondly, we are facing this in taxation field also. We have a OIDAR services, section 14 of the IGST Act, which says people staying outside have to register. Today, they have not, most of them have not registered, and we are not able to track them. The money is going from India, from every citizen of India who is using OIDAR services, and I am not able to collect the tax. They may be collecting and they may be looting. Because I don't have the data here, I am not able to manage that. I have lost crores and crores of rupees. This is what they are going to do. If it is pertaining to a data about A, B, C, D of us, if it is not available to us in India, what is the use of it? You say in the personal data that the principal, that's me, I can own and I have a right to keep it with me. But if you allow this as a lacuna or orienting towards the commercial data, you are showing more interest for the commercial data. Better not call it as a personal data bill itself. It is nothing to do. When you consider the industrial rights as paramount and fundamental rights are useless, then this is what is going to happen. That's my opinion.
okay, I would just like to add one point here that while we want to protect the privacy of 130 crore citizens of the country, nobody knows what is this right to privacy. Supreme Court 9-member judgment did not define privacy properly, or even if it is defined, it is called the state of mind of an individual. Now, how do you protect the state of mind of an individual? Now, how do I know what is there in Mr. Anand Patnam's mind as regards privacy as at this particular point of time? And I can make a law, get it passed in the parliament to ensure that protection. The right to privacy in the philosophical sense is a dynamic aspect. It changes from one person to another person. It changes for the same person from one time to another time. No law can actually protect the privacy strictly like that. So what the Supreme Court and various other people are saying is, let us look at giving a right of choice to the individual to tell the data processor how his personal data has to be collected, processed, disclosed, etc. That is all which can be protected in the data protection law, which is the information privacy. Therefore, the Data Protection Act has its limitation. It is not a right to privacy protection law. It is a right to protect the choice kind of a law. Beyond this, there is no other way. Mr. Panish, you have got to add anything? That is why the law has got more emphasis on compliance, what the organization should do. Mr. Subraidu has got some question. Yeah. Yeah, yeah.
Can a country force a company like Google to disclose its search algorithm,
Okay.
page ranking algorithm, or something?
Say this act has to work along with Intellectual Property Rights Act, which is we have got international commitments for that. So government is not going to actually override that. So within the provisions of what intellectual property rights law can permit, they will ask. They say, please remember that what we are seeing now is the 99 sections of the proposed act. There will be detailed guidelines which will come from the DPA. What the government may ask is for assurances. That's what I'm telling, that there has to be an audit, somebody has to assure kind of a thing. There will be no requirement of codes being, say, shared with the government or something like that, because that will be protected from the intellectual property rights provision. So I don't anticipate the concern which you are talking of. So probably this will be clarified when the notifications are there. Okay. Yeah, Mr. Srinivas has got another question.
Books of accounts kept in electronic form. It is kept outside India, it should be kept in a physical server residing in India. So it's quite
Common provision. And the Reserve Bank of India has said that if you want, you can process outside, because this was the demand of Visa and other credit card processors. They said we cannot transfer our engine to processing engine to India. So what Reserve Bank has said is, if you are compelled to process it outside, fine. But when the processing is over, please get the copy here. There are, of course, certain mischievous technology people who are saying, it's an interesting prospect. They are saying, what is processing? Processing includes storage. Okay, in GDPR context, storage is processing. So when I transfer this for processing outside and then store that data in my Visa server or something like that, it is continuing to be in processing. So I will never transfer it here. Processing is not over. Only after the processing is over, I will transfer it. Okay, this is an argument which I know that it is not a proper argument. But anyway, that is where TPA has to come and say that, no, what we mean by this is the processing up to this stage, and subsequently when it is in some kind of a static nature, now we have to define storage. When data remains static for a certain period of time, it becomes storage. Okay, when data is perhaps being processed in the processor for certain milliseconds, then perhaps it is continuing to be processing. I don't know, this kind of definition may come up. But even Reserve Bank of India has given that flexibility as far as the data localization is concerned. Otherwise, I feel it's a great opportunity for industries to actually develop more and more this thing. Okay, we will go into the next question. There is something which these startups and tech companies are raising, that ease of doing business. I would like Mr. Ramesh to explain the sandbox provision and say how sandbox provision gives 3 years of time for organizations to get into this compliance mode. Yeah.
I think our Indian law has got lots of plus points. I would say uniqueness to our law. One quite interestingly is this sandbox provision, right? The new technology which is emerging, as we know, whether it could be artificial intelligence to machine learning to anything. Then we are talking about the privacy coming into picture. Obviously, there is a kind of people have a fear that how am I going to implement it, and also we are talking about if I'm breaching it, penalty comes into picture, my brand image of my organization comes into picture, whatnot. So the sandbox provision, what they are talking about is quite interesting, quite unique. And the section 40 clearly addresses this that organizations which they are into new technology, new architecture, new designing, where they can use this provision, which is going to be provided by the government itself for a period of, so and so, which could be extended almost to 3 years plus, which is more than enough for any organizations to really see the stability of the product, right? Stability of implementing the privacy related issues within the system. And interestingly, it is not for anybody and everybody. Of course, you need to meet certain criteria. For example, your privacy by design policy as part of section 22 need to be approved, need to be submitted to the data protection authority. So they are trying to have a kind of real-time hand-holding, I would say. So I think this would help not only the big organizations, established, even for the startup companies, it will ease its pressure in terms of how am I going to adhere to what kind of cost involved, what kind of risks involved. So you are a little bit relaxed in terms of concentrating on your product, concentrating on your business, right? And I think this is one quite interesting stuff as part of our proposed law is concerned. I have not seen this particular provision, whatever laws we have gone through so far. So I would really go for it this. Yeah.
Mr. Panish, can you add to this? There are sandbox provisions already in the financial sector and other things. So,
Yes, sir. Yeah. So if I may add on this, the sandbox system provision that is given, it is not an obstacle to the startup ecosystem. And it is not an obstacle to kind of for innovation, be it in artificial intelligence, machine learning, or any upcoming technologies. So yeah, there's a lot of flexibilities that are given. Some approvals by SEBI and RBI also has to be obtained. So in that way, this kind of facilitates the startup ecosystem in coming up with some new business models as well. Okay.
Yeah.
Thank you.
So basically what the sandbox system means is that the exemption will be given for consent and other things, except security. Security will continue to be there. But you have to work within a protected environment, which is supervised perhaps by the DPA in some way, exact way in which I think the insurance industry has got a sandbox system. Finance industry also has got a sandbox system. So this will be something like that. You want to add?
Yeah, I just wanted to add, time is also given sufficiently, 36 months.
Yes.
And by the time we enact, it will take another 6 months. And their minimum 2 more years is required to make rules and regulations and the proper functioning to start. And another 2 to 3 years will be given. I think by the time the youngsters can come up and their entrepreneurs can be very much sailing along with the privacy laws. Absolutely no problem. That's a good move.
Yeah. So before we go further, I will try to answer one supplementary question which somebody has raised in the webinar. They say for cross-border transfer of sensitive personal data, apart from explicit consent, there is some requirement of approval from DPA plus central government. What is, can you elaborate? They have said. Say what it says is that, like you have heard of adequacy, Indian government also can declare certain countries or certain companies or organizations in certain countries or some sectors in those countries as adequate. For example, if I'm trying to say USA, which has got a very strong HIPAA environment, if any health information is to be transferred there, I can actually declare that as adequate for that, something like that. I'm just giving it an example. So that is one. Second, consultation will happen when BCR, that is the your binding corporate regulations, or even SEC, you have to enter into a contract with another company, then because the BCR approval is required from the DPA side. Between DPA and government, consultations will be happening from time to time for larger issues. Most of the other things like the approval of the BCR or SCC clauses, maybe we also may come up with standard contractual clauses of the Indian this thing, or a standard BCR template. If it comes, then perhaps you can use it, maybe subject to say reporting to the DPA. If it is something new, you have to approach the DPA. That is all the consultation which is required for adequacy and for BCR. Then if critical personal data is transferred outside India on emergency considerations like what we say vital interest in GDPR, medical emergencies, that happens without any permission, that has to be reported to the DPA. That is what it says. So otherwise the concessions for transfer will remain. Now, then we will come to the concept of consent manager. Okay, so the concept of consent manager makes our law unique. Unique in the sense that there is a new intermediary. It's a great business opportunity, I will tell you. In fact, I have been telling for last 3 years since PDPB 2018 has come. I have spoken to many technical people. I'll say, please let us start on consent manager. This thing, it is bigger than the biggest data processing companies in India, because consent manager will manage the consents given to Geo. Let us say you are going to have all the data which Geo is having. So what Paytm is having. So it's a big opportunity. And in the meantime, you should understand that there's a confusion in the terminology of consent manager, because the Ministry of Information Technology has come up with some framework, consent framework called DEPA, that is Data Empowerment and Protection Architecture. There also they have used a terminology called consent manager. But that consent manager is different from the consent manager of the Data Protection Act. The DEPA consent manager is an intermediary under the Information Technology Act who will allow the personal data to be transferred from a data giver to a data user with the approval of the data subject. But he will not have visibility to the data. The consent manager under DEPA will not know what information is going through, but he will only give the technical infrastructure. Whereas the consent manager under this particular act is a data fiduciary. Okay, so he is having visibility, he is having responsibility. Now, Mr. Ramesh can perhaps add certain things to this concept of consent manager. Yeah. Open that.
I think again, it's quite interesting concept, right? Especially I feel a country like India, where we have multiple languages, right? And even from the literacy level, the awareness of privacy issues, awareness on the technology part, right? This is going to really play a vital role. It's like, we already have financial advisors who is going to take a decision on my behalf, right? We have a contract in place, as we all know, many of the financial advisors. They say minimum, I'm guaranteeing this, etc. So I'm trusting the guy, I'm giving them same kind of here. If I do not know what is privacy, if I do not know how to really fill up a form, if I do not know how to give a consent, if I do not know the usage of technology, obviously this is going to play a vital role, right? For the data principle side. And as he said, obviously it is going to be a business opportunity for many of the organizations, right? Wherein I establish a trust with my people, data subjects, data principles. Obviously, more and more people are going to come. I'm going to work on their behalf. So I think again, it's going to be, it's in my opinion, it's a unique position which is being, promoted in this law. I think it will work out in a very big favor in terms of implementing this law also. Otherwise, because I do not know, I'm scared. I know even lots of people today, they don't want to even touch, phones. Elderly people, they feel scared, right? We have seen so many. So in this case, implementation of the law would also be easy. Adherence to the law also would be easy, because somebody else who has got knowledge is going to work on my behalf where I trust them. I think it's quite interesting. Yeah.
Add, on the business opportunity side for this consent manager, there are huge opportunities in terms of standardization and kind of interoperability. So these two are two areas in which a lot of business opportunities.
Yeah, one second. So very happy. Actually, this DPAS consent manager is totally different.
Right.
Similarly, when we read Chris Gopalakrishna's report about principle, there that principle is different. Our principle is different. But now Chris Gopalakrishna has come with the Sri Krishna. Coming back to this consent manager is a very good, valid requirement. Here, like income tax, we have income tax practitioners. In customs, we have customs brokers. We have GST practitioners, advisors, legal advisors. Similarly here, but here, one word of caution. They are also a fiduciary. So they get, it's just like a pool of data from there to consent fiduciary, they will exchange. But here, they should be evaluated in a very proper manner. Like there should be some stringent examination and how they have the technical and technological, this one, that should be tested. Their DTS score, data trust score, should be of the highest order. Even if there is a slight deviation, let us say 95, less than 95%, they should be stripped of it. Means they should be licensed and controlled. Otherwise, see here in India, we have digital literacy as far as usage is concerned. As far as complying with the law, every individual, 130 crore people of India have to subscribe. Each of their data has to be done. So they require somebody's help. The fellow should not be a mediator who will exploit the principal. So there is need of caution in selecting these people. Consent managers should be through tested means, and he should have facilitation, proper method. Simply if you make everybody as a consent manager, it will be like an election today. People elected and how they are ruling, we have seen. So to that extent, it will become, if I have money, I have this one, I will start ruling. Similarly, that will happen. So there is need of regular licensing methodologies, regulations, and there should be stipulation, and DPA should be compulsory. The data trust score, DTS should be compulsorily enabled.
Actually, this data consent manager will be a data fiduciary. He has to be registered with the Data Protection Authority as a consent manager, for which accreditation details will be worked out by the Data Protection Authority. So some of the points which he has mentioned, perhaps DPA will take care. Not everybody can call themselves the consent manager. It is a licensed business. License will be given by the Data Protection Authority. So that is the security which will be there. Now, coming to the next question, let me also answer one more question which is there on the web. If my software product is, this is from Yasub Jiruwala, if my software product is developed in India, deployed on the cloud, and used by users in UK, and we implement GDPR, will this be exempt from DPA is what he is asking. Good question. Now, this development is a different aspect. You can develop for anybody. If you are deploying it for the use of UK student, the UK people, then UK GDPR will be applicable. Okay. Now, if you want exemption from DPA, normally, because this is an Indian company, it will come under DPA. This is where section 37 of the Act says that you can get the notification from DPA for exemption. If you tell this DPA that this particular product is accessed only for processing the UK citizens' data, not Indians' data, you can seek exemption from DPA. For which, what assurances you have to give, what technical firewalls you have to build, that is something which you have to think about. I hope, Yasub, I have answered your question. And now we will go to the next. A lot of questions are there on data trust score, one. And second, on the if we am already compliant with GDPR, whether I am compliant with the DPA.
No.
Remember, GDPR is for EU data. This is for India data. So these two are different. Okay. If you are compliant with GDPR, I can say you are aware of what is to be done for most of the things. You can actually translate it here. Even HIPAA also is like that. If you are a HIPAA compliant person, I think that you have enough knowledge of what is privacy, etc. It can be made use of, but you will have to have a different implementation plan here. There will be some changes. Mapping will be different. Now, to address these issues of multiple data protection laws, as well as the DTS, now there has to be a proper framework. Now, industry is very well aware of ISO 27001, and whenever something comes of information security, that is the first mental recall. Okay. But that was done for a particular context, and they are revising it now and enlarging it for privacy considerations. Then ISO 27701 came for GDPR compliance. Okay, fine. Indian standard people came up with 17428. But somehow we feel that none of them are focused entirely on Indian DPA. That is why at FDPPI we said that we will incorporate the best practices of all these frameworks, but have our own indigenous framework. That is what we call as Data Protection Standard of India. Maybe this concept Mr. Ramesh can explain more, because he has worked with me very closely on this particular concept, how this helps in unified compliance and particularly the DTS concept briefly. Of course, we don't have full time for this, but as briefly as possible. Yeah.
Actually, this we started working on this personal data protection standards of India. Probably it's a 2-year-old history, right? Now, as he mentioned, we have also changed that from the to align ourselves with the new law. We have changed it to data protection standards of India. Believe me, 2 weeks back, I was attending a seminar, online seminar, international seminar on the same kind of 27001, 27701 data privacy related questions seminar. There was a question asked by somebody from US that, look, I have kind of situation wherein as an organization, I need to adhere to, let's say, GDPR, to Singapore, PDPA, to, let's say, HIPAA or some other frameworks. It's becoming a kind of nightmare, right? What is the solution we have? Believe me, I was muted, as many of the programs are always about to jump to tell him that, at FDPPI, we really talked about it 2 years back, and we do have a framework. Happy to introduce to all of you that we have at FDPPI Data Protection Standards of India, where it addresses these kind of questions what's emerging in the industry. Now, if you are having a kind of organization where I have to adhere to GDPR, to FDA, to HIPAA, to etc., this framework DPSI is going to be the solution, right? It has been designed in such a way that it comes with the two important aspects, like what we call standard implementation specifications and model implementation specifications, right? At the top level, it gives you the kind of flexibility to address the organizational views supported by the implementation aspects of the organizations. We are talking about 12 standard specifications and implementation specifications around 50. Be with me again to give you the kind of enough confidence that we have done these standard specifications and implementation specifications mapping with respect to almost all the laws what we are talking about today, starting with even the frameworks like ISO 27001 to 27701 to 17428, what Mr. Navi talked about, to GDPR to CCPA, right? Now, quite quickly to touch upon the 12 standards implementation specification, what is going to help you and me to prescribing to the organization is that concentrate on compliance plan, identify what kind of laws you need to adhere to, because each law comes with its own penalty, which is quite huge. Talk about an effective governance system within the organization, involve key management personnel, what we talked about, KMP, right? None less than the director of the organization, and concentrate more on the risk management practices to understand what kind of privacy issues are the risk or the harm to the data subject or the data principal, And obviously, we are talking about privacy by design, privacy by default, right? Here, the concept we are trying to promote is at the entity level, not only at the business level. So the moment you're talking about getting a business to your organization, apply your concepts on privacy by design so that you are going to involve all the key stakeholders organization, starting from top to, the practitioners level. We are also talking about compliance responsibility, because that's where the top management involvement is going to happening. We're talking about effective communication plan, which is the kind of important criteria for any program to succeed. And we are talking about implementing the technical measures, right? It could be the firewall, what we talked about, network security, operation security, communication protocols built in. And we are also talking about administrative safeguards in terms of, right, bringing out the policies, training the people, creating the kind of compliance culture across the organization. Otherwise, we are not going to succeed. And appropriate measures in terms of, setting up the standard for data trust code. Again, I would like to I'm really fascinated the kind of concepts which is emerging out of our Indian data protection law, which is unique again, data trust code. I don't think almost all the laws doesn't prescribe about the data trust code. Quite interesting. Evaluating the organization's implemented measures at a regular interval, as we have management system standards, right? We have a regular periodic audit, we have surveillance audit, we have recertification audits. Of course, the effectiveness is a different debate, as he touched upon. For 15,000 rupees, I know organizations talking about for 5,000 rupees certificate. Okay, don't approach me, by the way. We are all very stringent guys with respect to implementation of the quality, right? And what we are talking about is making sure that the data score is going to be established for the significant data fiduciaries. It is going to be audited by these skilled auditors. Again, I would like to bring in here the concept of, we already have a mechanism at FDPPI where we have almost around 40 trained data auditors today for the industry, right? We are little bit ahead, in my opinion. We are not waiting for the code of practices to be defined by the Data Protection Authority of India, where I can say, Mr. Navi, we already have the DPAI, where we have already established the CO Center of Competence for this topic, where we have also established how to calculate the data trust code, how to evaluate the data trust code of this DPIS framework, what I talked about, how to really look at the effectiveness of the implementation, how to really look at the improvement, is it happening over a period of time, right? Because data trust code is becoming a mandatory ingredient of this proposed law, right? Organizations need to, as applicable, need to publish the data trust code even in the websites, need to publish as part of the notice to the data principals at the time of collecting the data from them, that what kind of DTS they are operating, because that's where it's going to give you the kind of like a credit rating, right? A+ and etc. what you're talking about. When we are running a security vulnerability on a product, it comes out, it's, you are A+, then we are happy, right? That kind of system. So to summarize, the implementation specification that 50 also is talking about different kind of, we have categorized beautifully across all the domains, I would say. For example, we have categorized into, areas like management controls, data protection officer as an organization, around 10 controls being associated. Legal, we are bringing in. HR, human resource, which plays a vital role, we are bringing in. And technology aspects, which talks about 114 control software, 27,001, which beautifully mapped with respect to. Again, all these things are interrelated, if I had to conclude it, right? We are talking about certification of software, hardware as one of the unique points from this data protection law, which we are addressing in our DPSI. I would humbly request each one of you to log into our DPPA website, go through this DPSI framework. You will really appreciate what we are talking about. Yeah, thank you.
I'd just like to add one line. We have been a very intelligent society from the beginning, but very unfortunate we depend on foreign brands or foreign standards to be adopted. It's really not 27,000. We should have our own product. With that in view, now is leadership. We have started it and we have achieved it. People like Ramesh and other professionals in and around have helped us. It's our own product. There is a foreign exchange outflow when you buy a foreign standard, and it will not meet the requirement of the Indian law. And tomorrow, when privacy law comes, Each and every MSME, each and every businessman, each and every person who is having data management things cannot afford to go for the standard. Then you cannot implement your law. That should not be the situation. So we have our own product, which meets to the requirement of Indian law and all other international laws. It has complied with GDPR and all other things. So when that is the situation and it is a local product available, it makes sense not to allow others to flourish here where we have our own intelligentsia and our own product. With that in view, this is a very good mission and every business organization should switch on to this kind of product, local product, where we can comply with our law without any worry. Thank you, sir.
Before I ask Mr. Pranesh to give his views, I would like to add a few things here. This DPSI is a open standard in the sense that most of its thing is going to be made available free, except implementation will be done through consultants. So certain templates and other things will be proprietary to the consultant. We have already created the data auditors with some skill sets and also the certification bodies. We are having our training programs in which we teach them the Indian law, the global law, and this DPSI framework and audit in complete details, so that the persons who are certified as the auditors under this have a fairly good knowledge of what needs to be done, except that every such skill has to be developed by the person. Everything cannot be taught. In fact, as we go forward, we are interested in FDPPI developing what we call as patron members who are picked from each sector, different sectors. If possible, we will have one patron member from one sector. I want that patron member to develop himself into be a corporate privacy champion for that sector. Work with us, we will develop this codes and practice. This is coming under section 50, codes and practice of this thing. We want to develop codes of practice for each industry, for hotel industry, for hospital industry, maybe for software development, maybe for fintech. Each of these segments, we want to develop codes of practice or an amended or modified DPSI or instance of DPSI. DPSI is a standard, but certain instances of that will have to be developed. For example, EdTech, educational companies. For each of those people, we want to develop special expertise, and our DPSI can be modified into all these things by templates. The standard will remain the same, but template of privacy policy, template of disclosure policy may be different for each of these things, which we would like to work with the industry person and develop it so that before the Data Protection Authority of India assumes office, I want to present at least 4 or 5 codes of practice for different industries and say that we have done this. Of course, they will give the final approval. They will give the accreditation, what needs to be done. They will give everything. On DTS also, they will give a perhaps guidance and other things. But we will present them with something on which they can say, okay, I don't like this, you change it. I like this 20 or something like that. It will be easy for them. In fact, we are making their work easy to make corrections to our DPSI and pass it as a code of practice for the industry. The law provides each industry to have self-regulatory measures and get it approved by them. So instead of complaining that something is not applicable to me, I have to develop a self-regulatory thing and then go to them. This is where I would like Mr. Pranesh to specifically respond as an industry representative, whether this concept will work, and if so, how, what thoughts he has got on this.
Yes, sir. So the first point I wanted to mention was on simplified compliance solution that is there. So as part of GRC team, governance risk compliance team of any organization, we are subjected to several audits around the year. So main objective for us should not be to face the audit and complete the audit satisfactorily, but for the organization that has invested to show the implementation and continual improvement. So in that regard, this simplified compliance solution that is going to be very useful. I just wanted to mention that. And for the second point, for the COPs, we at IACC, we have representation across the sectors. So be it healthcare, be it IT, ITES, hospitality, defense, aerospace, manufacturing, construction. So for each of these companies, how this part of this new law is going to be applicable, sector-specific implications that can be an initiative as part of the cybersecurity forum, which is there at the South India Council. So we would want to organize awareness session and various training sessions with this sector-specific focus in mind, so that the implications of DPA for these sectors could be understood. I think, yes.
Thank you, Panish. We are coming to the end of our time slot. Before we take the last 1 or 2 questions, I would like to complete some of the information which I have to give. For further information, where do you see? One of the requests which have come is, where is this DPA 2021 bill? There is a website called dpa2021.in. You go to that, you will have section by section or chapter by chapter information. You also have the PDF version of the bill only, or 242 page version. And if you want a larger version where JPC debates and other things, all information, everything is available. If those of you who want to make a research on that, there are dissenting notes submitted by some of the members. All that information is available in DPA 2021. There will be a comparison between PDPB, and this also is available. That is also in the last link. There is this thing. That is, you can compare PDPB 2019 and this side by side. So that is for raw information which is available. Then we are actually starting a new training program on this DPA 2021 starting from April 2nd. And in fact, all the people who have registered and participated in this program, either in the physical or in the virtual, have been provided a special discount for attending this new Module I program. We call it as Module I because it's a module on Indian law. And for becoming a DPO, we want people to also study Module G, which is the global law, which contains GDPR, CCPA, Singapore law, maybe Brazil law, maybe DIFC, Dubai law. That is multiple data protection laws we teach in that particular thing. And this DPA 2021, even at this stage where it is a draft, I have already produced one ebook, which is in Kindle format, which is available in Amazon. People sometimes ask me, before the act is there, you write a book and do you want to make money out of it? But my idea is, before the act is passed, people should know what is there in the act. Okay, so it is in the Kindle format now. I had a print version of the PDPB 2019 earlier, which was current for 2 years. Now, after the changes are made, this Kindle book will also be converted into a print this thing, but I have not produced it right now. So information is available on the website, but of course, most of these discussions happen in my website called navi.org. So FDPPA website is more like a corporate website, only few things are put there. But information on any of these discussions, you can refer to this ebook, that is Kindle book, DPA 2021. You can refer to my website, navi.org. Rob, this thing you can read in dpa2021.in website and develop your own thought processes. And you are welcome to even contribute your thoughts to FDPPI so that we can consolidate and keep the ministry informed about the industry opinion. I want genuine industry opinion, not colored by the Economic Times and other media kind of a thing. They have got their own reasons to write. So I think that is what can be done. Those who are interested should look at this training program. We have actually priced it at only 12,000 rupees. Out of it, 2,000 rupees discount, 10,000 rupees is I think is the evening dinner budget for many of the software people. But we believe in knowledge being dispersed as widely as possible. Money should not be a barrier. Okay. So many people ask, if you make it so cheap, people will think the course is cheap. Then no, that is not our intention. It has got its own value. But we would not like to make it unaffordable to people who are on the borderline. So that is why we have priced it like that. In fact, people who do all these three programs, they spend about 40,000, or the consolidated thing which charge 40,000. At 40,000, you will know Indian law, you will know GDPR, you will know CCPA, you will know Singapore, and the data audit kind of a thing. Remember, this law wants mandatory annual data audit to be conducted by significant data fiduciaries, and also concurrent data audit during the year. So you can imagine how much of potential is there for professionals who are data auditors. Data auditors are different from financial auditors, different from security auditors. So this is a new profession which is coming up, and I feel people should actually start studying and empowering themselves with the skills, and not only contribute to this data protection regime, but also enhance their own capability. So this
Yes,
is,
one line.
yeah.
I had the opportunity of reading the Navi's book, which has come out. It has come out beautifully. Within 2 days, I could read it, and I enjoyed every bit of it. Most of my learning is from that book, sir. It's very well written, very
Okay.
well advanced book. It has a stream of philosophy to start with, from ancient India till date, the wisdom of the ancient things. Plus the modern technological innovations are there in addition to the law. All these three have come. I said it's like a Triveni Sangama. The book is so beautifully written for a person interested in ancient wisdom, how it has generated into the present day, as well as technological, how we have grown. There are discussions on artificial intelligence there, and there are legal discussions starting from the earliest law of IT till date. So that's a beautiful book. Triveni Sangama, I want to call it.
Thank you. Thank you. That's, I'm going to say that information is available, but it is for people to actually make use of it. And professionals in FDPP are also there to handhold you if necessary through these training programs. I want industry to make use of it, and organizations like IACC needs to actually work in this same direction. Take our assistance if required. We will have some joint committees and other things, and we'll work together. And I've also given him a very important proposal. I will discuss it later, how to make Bangalore the center of data protection in India. I don't want Delhi to be the center. I want Bangalore, which is the Silicon city, to be the center. I've given some thoughts to him. I cannot do that individually. Okay, I can only dream. Okay, but actually I can have a dream 11, but IPL has to be done by somebody. Okay, so I think the organizations in India were to get together in Bangalore in particular. We have to get the top IT companies here to come together, and maybe we will work on how to. All this should happen before the act is passed. Once the act is passed, it gets frozen. Before the act is passed, I want some action to be taken in the state of Karnataka and Bangalore, which we are proud that it has been the earlier Silicon city. Now Hyderabad is competing with us, Noida is competing with us, Pune is competing with us, perhaps three these things. And people in Delhi will have their own advantages. If things happen in Delhi, there will be more of politics. If it happens in Bangalore, there will be more of technology and professionalism. That's what I believe in. Okay, because our culture is more of professional these things. Bombay culture is more of commercial things. Delhi culture is more of politics. So I think this data protection has to develop in the Bangalore culture, and then it will be better.
Yes, sir. I totally agree on this. Karnataka has been the hub of innovation. The Mahatma Gandhi station, power generating station, was first set up in Sharavati in 1902. So from that,
Vishesharaya.
yeah, we have a long heritage and legacy there. So with respect to the IT revolution also, Karnataka has contributed a lot in terms of IT exports and job generation. So with respect to the data protection as well, there is no excuse that we should not be one of the leaders
Yeah.
of data protection in India. So yeah,
So-
look forward to it. And
Yeah.
as part of IACC Cyber Security Forum and IACC Karnataka, we are going to take this initiative of some of the sector-specific initiatives and implications of data privacy. So it could be more awareness trainings and handholding of our companies in these sectors so that they can show compliance, because this is going to happen. It's imminent. It may happen now, it may happen in few months. So, but it is going to happen definitely. And for the organizations, they need to show the capabilities. It could be people, process, and technology capabilities to show compliance. Okay. So,
So-
as an organization,
Thank you. Thank you.
IACC is kind of
Yeah. Of course,
supportive for this initiative.
we cannot
Thank
carry on endlessly, so we have to close it. So let me thank all my panel members for adding their views, and also IACC on my behalf, FDPPI behalf, for having given this opportunity. We hope there will be more opportunities to continue this relationship, and request Jitika to take over. Yeah.
Thank you, Mr. Nami, and all of the distinguished panelists. Thank you, attendees, for attending the cyber seminar today. I would now like to invite Mr. Supotik back, our National Executive Council member. For the conclusion.
Let me first get over with the formal part of what I have to say. We've had the privilege today of talking with some really knowledgeable experts on the subject. But I could for their very insightful comments on a subject that is very new to many of us. This is a matter that's become of great importance, and perhaps deep engagement for people at the managerial and at the board level. It is something that will engage us for a very long time, and it's time that people started paying some serious attention to this. Those boards that have been that have had foresight have already started seriously on these lines, and those who haven't would be well advised. This is reality. It is happening. It is going to happen. We have, as Mr. Kodandaram pointed out, been a nation that has been slow in moving with times. We are still living with laws that are 150 years old. This is going to change. Whether we change or not is not material. Those of us who don't change, we are going to be left behind. So it's time that we pulled up our socks and said, hey, this is something that we need to do pretty quickly. Let's become adept at doing what needs to be done. I also think that the point about compliance by design, or privacy by design, is the philosophy that we need to follow. I'd like to, so as I conclude, I thank all of you for being here. I thank the audience for being here, and those of you who have joined us online, thank you for being here, and for Jitika and others in the IACC for organizing what must be a really insightful session for all of us. I'd like to leave you with one parting thought. Okay, and this is that, as Mr. Nadu pointed out, there is this balance between the three entities: the individual, the corporation or business, and the government. I'd like to suggest to you, think about it, you might not agree with me. I'd like to suggest to you that the interests of these three parties are not divergent. They have to be congruent. And the wiser businesses will think like that. My interest as a corporation cannot be different from the interests of those I serve. That is, my stakeholders, whether it's a shareholder or an employee or a customer. our interests must be convergent. And if we think like that, you will find that it will be easy for us to accept this, get along with business, get along with delivering the value that we know how to deliver. And all of this will fall in place if we work with this philosophy. And so with those words, I thank you very much once again. Have a nice day. Now this is